Good morning. I will now call to order the February 6, 2019 public hearing to consider a legislative amendment to the county zoning development ordinance related to recreational marijuana production. Before I begin, I'd like you to join me in a pledge of allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Today, we will conduct our deliberation on ZDO 271, which is a legislative text amendment to Clackamas County Zoning Development Ordinance, which proposes to limit the number of licensed premises for recreational marijuana production and the number of registered grow sites for medical marijuana production on property zoned ag, forest, exclusive farm use, or timber. The amendment also proposed certain non-substantive text amendments to clarify certain marijuana-related land use regulations. Over the past few months, several people have attended our meetings. Several is a kind word. A lot of people have attended our meetings on this issue and presented written and or verbal testimony to the Planning Commission and to the board. And a large amount of information has been submitted into official record. Today is a continuation of the Board of County Commissioners land use hearing that began on January 16th and is now reserved for County Commissioner deliberation decision only. Assisting us in the hearing today is our clerk, Kevin Moss. Planning Director, congratulations. Jennifer Hughes, Planner Glenn Hambert. From the Planning and Zoning Division, our Assistant County Counsel, Nate Boderman. With that, we'll begin deliberation. What do you want to deliberate?
Well, I'll start.
Go ahead.
Okay.
I really appreciate everybody who took the time to give their thoughts and opinions on this matter that's in the record. Really helpful to bring it home for us what the issues and concerns are. So I just want to acknowledge that.
Well, I guess, we've had a lot of discussions, I'd say the voters who legalized marijuana had something different in mind than what has occurred. And now after the reports that 50% of the we have 50% more marijuana than we need, and there's 5 years of marijuana on the shelves, it seems that we've limited we've probably hit the limits of grow needs, and there are people still proposing grow sites, and condoizing was not a thing that was considered back then. Certainly when the voters voted for it, they never even imagined it. So, I don't know. Paul?
Well, I do know that there were some comments that were made by some folks here at the last hearing with regard to that our efforts were, I think, perceived. Their comments demonstrated that their perception was that we were somehow regulating the supply by our actions today. And I at least personally, and that may differ a little bit with what you just made your opening statements on, Commissioner Bernard or Chair Bernard, and that is that I don't believe that our effort is, I think that's more of a state issue to limit the control. It's more about the intensity in a particular area than it is about the volume, that's not our role. We can't really do that. We can't really regulate the supply in the state by simply doing what Clackamas County does or doesn't do. Have an impact, per se, if we did something, aggressively one way or another, we could impact the supply a little bit. But I think our role is really about, my concern has been about the intensity and the impacts to local neighbors and the issues there. I said that then. I want to make sure that at least that's clear. And I want to understand that I think even the Planning Commission was really looking at that as well. That's looking at a question back. So it's not about us controlling the supply. it's about us controlling the intensity in the area. Is that correct?
Yes, I would say that's correct. The Planning Commission had a lot of discussion of sort of balancing the needs of the industry. They were not insensitive to that, or property owners who were interested in production, and balancing that against the concerns of the surrounding residents and property owners. So yes, it was more about that than supply.
Right, right. I also did want to say that I really appreciated the creativity that the Planning Commission came up with regard to having a tiered number of opportunities to put these sites on based on the acreage. And I'm not probably getting that exactly right as they did it, but I think that was pretty creative. However, I don't think that's the way I necessarily want to lean here this morning. I don't know where my colleagues are, but there's the issue about one tract of land or one lot of record, and because there's 3 different scenarios here about how we go about it. So I just wanted to make that one clarification, getting back to my original comment about the intensity versus the supply.
Well, thanks, I appreciate that, and that's the basis of my concern, but I also have concern about how much marijuana is being grown. But we don't have the ability to regulate that, but we do have the ability to have some impact on it by adopting restrictions, and we've done that all along. But our main role is to protect the citizens of Clackamas County from the impact, the negative impact. Ken?
Well, thank you, Mr. Chairman. I think that most people that voted yes on the legalization of marijuana did so in good faith that it wasn't a good idea, and in my personal opinion as someone who worked in law enforcement, I still don't think it's a good idea to lock up people for smoking a joint. And I think that most people had come to that conclusion that voted for it, and that's why they voted yes, figuring that as long as people didn't drive a car, they wanted to smoke a joint, they grew a couple of plants in their own yard, that society could live with that. I don't think that anybody anticipated what has occurred by making it a crop. Unfortunately, as I was talking to some folks earlier today, the law of unintended consequences came into play on this one. I've met with people from the industry, and I have met with people who live in the neighborhoods that this is impacting, and I've come to my conclusion on this in doing what I consider to be due diligence and listening to both sides of it. Part of the purpose of land use planning is to balance the impacts of our uses on our land with the impacts that they have on our neighbors. It's why residential is here and farming is here and industry is here and commercial is over there. So we minimize the negative impacts as much as possible. Right now, I think we have a situation where in this particular case, the negative impacts outweigh an individual's right to just do any darn thing they please on their piece of property without regard to the impact. So I am prepared now to make a motion when the chair is prepared to accept one and move forward, Mr. Chairman.
Martha?
Yeah, I'd also like to echo what Sonia said. Thank you all for showing up. And I have a clarifying question of staff. Now, folks from the Springwater area have come to talk to me, and am I to understand, even with these changes, since that has already been approved, that we'll move forward as is? I think Ken and I have had a discussion about that. Spangler Road, Spangler Road, yeah.
So typically with any land use, well, we would look at it through what we call a non-conforming use lens. And this notion of non-conforming use relates to a legally established use, a legally approved use that is allowed to continue even where the regulations have changed. And many people call this grandfathering, whatever you want to call it. It's the recognition that it's equitable for certain uses to continue even where regulations have changed. And so in the case of approved production operations that have licenses, that have built out and are operating, very good chance that they would be allowed to continue at that scope and scale. For those that have perhaps received approvals but have not obtained licenses, have not grown, there's an open question in staff's mind as to what would be allowed to continue. And so each of these are evaluated on a case-by-case basis. It's hard to categorically say one way or the other what license, or I'm sorry, what production operations that are currently approved will be allowed to continue at a certain scale. But the things we're looking for primarily when we evaluate a non-conforming use are whether they've received approval, because you can't have a non-conforming use unless you've been legally established in the first place, whether they've received a license from the state, and the scope and scale of the construction on the property. So those are the primary things that we would be looking for.
But it is appealable, or it would have to go through a
Correct,
process
yeah,
with
the
public-
evaluation of a non-conforming use is a land use decision, and so that would go through a quasi-judicial procedure, which is subject to further appeal.
Okay, thank you for that. I wanted to clarify that for the public here today, and I'm going to editorialize a little bit here. But to me, this is another example of our state legislator not looking to on-the-ground governments at cities and county levels, because I can't begin to tell you, I will tell you, the amount of time, effort, and distraction having to deal with this in our county in terms of what we need to be doing with our planning department. It really had derailed some other major things that our planners were doing, and it's taken at least 3 years, thousands of hours, a tremendous amount of taxpayer dollars, in a sense, when you think about this, because we were really left with a very murky directive, and how are we going to implement this as the will of the people? I don't think OLCC does a great job with what they're doing in terms of, just my personal opinion, and of managing the retail side of it. And while I do recognize that there are some medical reasons for people to smoke marijuana, it is not treated like any other regulated drug, which I think is absolutely ridiculous. And finally, I'm going to end and tell people to try and find the article in the New Yorker that was just written by Malcolm Gladwell. He actually talks about, I see a head nodding, I hope you found the article. He talks about how we're doing this backwards. He talks about, again, the substances that we're dealing with today are quite different than the substances 25, 30 years ago. There's higher, evidently, titers of the substance that causes hallucination, everything. It's a different substance today. So not only is there that, there really hasn't been any in-depth true studies about what the negative consequences are. And one of the things that I think really made me fearful when I was listening to him talk on NPR was that, for example, they are finding statistical evidence that early smoking of marijuana or continuous use is actually linked to a higher incidence of schizophrenia. And I'm not just saying this to be an alarmist. This is some of the data that he's kind of moving forward. So it's data-driven. I'm not trying to say, marijuana, I'm not into the whole reefer madness things, but it's definitely has psychotropic things that are wrong with it, and it should be regulated, and making it legal before we had the rest of this in place has just never made sense to me. So that's my editorial, and I'm ready to read the article. I'm not just, please read the article. I thought it was a very wise way of approaching how we deal with drugs, just drugs in general. We have an opioid crisis, for goodness sakes. It's just opening the door to so much more. So.
Oh.
I just want to thank everyone for reaching out to us on all sides of the issue. I recognize that there are people in the industry that are very responsible and I would call them the good actors, and there's been some folks that have really been on the other side that have not been very cooperative or friendly to their neighbors and so on. So I just want to recognize everyone, and also appreciate all the input. I'm sure a number of us got quite a bit of input from a lot of you, and some of you asked me to read some of your comments, there's just probably too much of that to do, but it's definitely in the record. I think that there is you know, it did factor in, or it's probably going to factor into my vote today. I don't know where my colleagues are exactly. I did want to also say, in the history of this, as far as the commission's involvement, some of the communications indicated or suggested maybe that, or maybe they are misperceived, that maybe we were been in alignment. The Board of County Commissioners had voted 5-0 on this marijuana issue from day one. I can assure you that's not the case, and some of you in the audience know that. So I don't know how we will vote today, but I just want to say that the board has not, this Board of County Commissioners has not been united on this topic from the beginning. Perhaps today we will. That's not to, it's not to direct any negatives or positives towards any one of my colleagues on the commission. My guess is maybe today we'll be united on this one. But it has been very difficult, been very controversial. This has been painful, this whole series. And had we gone a little bit different way, I don't think we would be here today. We have the significant impacts that we do today already had we taken a different course of action. But we are where we are. We've learned a lot. And I'll just say it's, I thought it would be bad. It was just happened to be worse than I thought. I'll leave it there.
Commissioner Fisher.
Yeah, I just want to clarify, we did get a lot of input on Spangler Road, and I know you answered Commissioner Schrader's question, but I want to make sure that I understand it. So if we make a decision to limit the license per track today on that particular piece of property, if I'm understanding what Nate said correctly, it is approved but not licensed, and so it would have to go through a non-conforming use process? Is that the
I
status
guess
of that?
we're still a little unclear whether it's licensed or not. I think that based on the best information we have, we don't think that it is.
We think it's unlikely that it's licensed.
Okay, so it would go through a non-conforming use. So what we do today
Or,
could affect
or a
that.
vested use, which is a,
Or, say that again.
or a vested use, which is a form of non-conforming use analysis. Yeah, either one of those essentially looks at how far along the operation is and whether it's equitable for it to continue under the old rules.
Okay, so basically, what we do today may or may not affect that.
Correct, and either a vested right or a non-conforming use application is a land use decision that will include notice to neighbors and an opportunity to participate in the process.
Okay, great. I just wanted to make sure that I understood it correctly because
Clarification too.
I don't want people to think whatever we do is going to just solve that problem in their mind, but that we're setting really a policy for a land use decision process for the future, so.
So I have a clarification question on that too. Vested, you use that word. The other one was if they're built out. I assume these buildings aren't all built yet, so it would have an impact. But you used the word vested. Now, normally that means a certain percentage of money has been put towards the, let's say, the building. So what, define that word a little for me.
Good luck, right?
That's like reasonable.
If only we could.
Yeah,
Goes
yeah.
back to way many
Well, let me
hundreds of years ago.
let me give you some characteristics here. I mean, certainly the buildings on the ground, you know, how long an operation is, or the contemplated scope of an operation, whether the funds were expended or whether the money towards the operation was expended in good faith. In other words, whether money was spent after it was known that the regulations were changing. That's a factor that goes into the analysis. Ironically enough, sort of the capstone case that people often cite to for vested rights came out of Clackamas County back in the 70s, I believe it was, and you'll still hear it cited all the way up in the Court of Appeals and Supreme Court when it comes to these. And you know, and it's a difficult analysis because it is very fact specific. I mean, you can't again categorically say that these types of operations will or will not be vested because you're looking at the percentage of expenditures compared to the anticipated amount of build out, and that's going to be different in every single case. And so. Again, in the context of marijuana, I tried to, highlight a couple things that staff would look at as being particularly influential in a decision, such as whether a license has been obtained, whether the buildings and the types of infrastructure that's built is specifically related to the growing of marijuana. Again, it's a crop, and so if you put up a greenhouse, it's not to say that that's specifically for the production of marijuana. It could be for the production of other crops that are customary in the area. So, again, it can't categorically say one way or the other, but those are the types of things that we would look at, and in fact, the Supreme Court or I'm sorry, the Court of Appeals in that case has endorsed is the factors that would go into a vested rights analysis.
So just to follow up, I've experienced this myself. So a marijuana grows, they go out of business. It sits there empty for a year. Then they would have to go through the non-conforming use process if it wasn't utilized for over 1 year, correct?
So if the use is discontinued for more than 12 months, then they don't have a non-conforming use anymore. Now, again, somebody could file an application. In that case, it would be for what's called a verification of a non-conforming use and present their evidence as to why they think the use didn't cease. But in the end, if the conclusion was that they had stopped for more than a year, then they lose it.
Okay. So it was Ken, Paul, and Martha, right? Yeah, Ken?
First, I wanted to thank staff. Yesterday, you met with me and several different citizens, several different times, and, over a course of about 2 to 3 hours, so I really appreciated your efforts. I wanted to thank you in particular. I'm sorry I've forgotten your name. Glenn, thank you, for driving out there and taking a look at the site yourself and letting me know what has or has not been done in terms of earth moving or buildings or anything else. And it's good to know that nothing's been done at this point. So I very much appreciated your efforts on that. Because the Spangler Road issue is going to be coming forward in the future, either before the Planning Commission or us or both, as the case may be, would you follow through on the request that I made about notification further out than just 750 feet? Can we do that?
I think we have to change some rules.
Yeah, so that's potentially problematic, just in the sense that our code right now specifies a specific notice area. And so if that's something that we want to amend in the future, that's something that we would build into the code. Now, state law dictates a minimum level, and for the most part, we have abided by,
Exceed it generally.
according to our planning director, we exceed it. We also provide notice to CPOs and others that we aren't necessarily required by law to do. Now, if you want to expand notice in the rural areas, and I think it's worth mentioning that there isn't a static line in state law for notice, and so notice in the rural areas isn't the same as notice in the urban areas. It's going to be larger in the rural areas just in recognition of the larger parcel sizes. But that being said, if there's a desire to notify even further out, that's a change that we would want to make in the code specifically.
Okay. Well, I'd like to see that come forward. In the meantime, when the Spangler Road issue comes up, would you notify me, please? Thank you.
Okay, next, Paul.
So I just want to say, I know that we've been talking about particular properties or applicants and so forth, and I just think I think it's safe harbor for us not to get or base any decisions based on any one particular site or applicant. I'm not thinking that way. I'm thinking about holistically about how this impacts the county at large, and so I've been very careful about how I have thought through this and spoke about this particularly, and it's important to realize that what we're doing here, and staff has guided us, I think, properly in saying they don't know particularly how all these different situations or vested rights or however it may be is going to work out in the end. And so this is not about a particular applicant or a particular property for me. This is really about, you know, what's in the benefit of the, or what's in the best interest of the county as a whole.
Martha.
Yes, I concur with that. Thank you, Commissioner. The article's name, I just looked it up. It's the January 14th, 2019 issue of the New Yorker, and the title is Marijuana as Safe as We Think? Permitting pot is one thing, promoting its use is another. So I would suggest that the public get a hold of the recent issue of the New Yorker, find it online, read it. So, thanks.
Ken, I'm ready. Are you?
I am. Mr. Chairman, I would like to move to approve ZDO 271 as recommended by Planning Commission and staff with the following changes. To limit a tract in AG, F, EFU, and TBR zoning to only one licensed premise per tract for recreational marijuana production by OLCC, or only one medical marijuana grow site registered with OHA.
Is there a second?
Second.
It's been moved and second that we approve ZDO 271 as recommended by the Planning Commission and staff with the following changes: to limit a tract in ag forest, EFU, and TBR zoning to only one licensed premises licensed for recreational marijuana production by OLCC, or only one medical marijuana grow site registered with OHA. Any further discussion?
I do have a question, and that is, I just want to clarify with staff that on page 3 of 138, that under section 2, that A, B, C, D, and E are part of that, those changes as recommended by staff or the Planning Commission?
I did ask that they write me this to include that, and that's why we had to do approve ZDO 271.
Right. Just want to confirm.
All right, so any further discussion? What do those signs say? All those in favor say aye. Aye. Opposed? Abstaining? Motion carries unanimously. You were right, Paul. Now that the amendment has been approved, I'll direct staff to draft an ordinance reflecting today's decision and include it on an agenda for a board adoption at a future business meeting. With that, we'll close the hearing on ZDO 271. Thank you.